23CR 1254 is now called the State of Texas versus Christopher Caleb Watson, who is here with Mr. Adams, his attorney, and the state's attorney is here. Does the defendant waive formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about April 25th, 2023 in Jefferson County, Texas, you committed a state jail felony of burglary of a building. Do you understand what your charges are?
Yes, sir.
If convicted of a state jail felony like this, you face confinement in the state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty and sentenced to 18 months in the state jail. Restitution is ordered in the amount of $600. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How are you going to pay the restitution?
I don't know.
How are you going to pay the restitution? They need to get, well, that their plan needs to be in place before I accept the deal. I mean, I don't have to take this deal. The victims want their money back for the loss.
I didn't pitch restitution.
How you going to, sir?
I didn't pitch restitution, so this came from you. Restitution.
Yeah. Well, I'm not going to take a deal if you don't have the money to pay it. You can just sit it out for 2 years.
Judge,
No, that's what the people want.
Judge, hang on.
You're going to you broke the front door glass. I guess it's probably for that. That looks like what the damage is. It could be that much, you know, if it's a big door. It's all glass. But it's not a debate. It's they for the for six. They said they're owed $600, and I deal with the people. They're just not defendants in the trial. You got victims.
Yes.
And victims have a say. It was a loss. And we're going to try to accommodate them when they are lost, on a loss. People will say, why are they making a deal? And I'm out the money. What did they do to get a deal? And I have to deal with those directly, sir.
For you.
Sir.
For you.
Sir?
Oh, what's your judgment on the case?
It's 600. You're going to have to pay $600. I'm not going to take the deal, sir.
600 is not days.
Sir, I'm sorry. What you said?
600 is not days. It's money.
600. Okay, fine. I understand that. I don't have to take a deal.
So
So we'll just put it on the trial docket, and when it gets around to getting ready for trial, we'll try. That's what we'll do.
I don't know what restitution is.
Restitution is payment for loss,
Oh,
and the people say they lost $600 worth of something, and it's apparently the glass that was broken when you burglarized the building. I don't see another loss, but that has to get paid.
but it was lost.
$600 loss, and they're going to say, "Why did he get a deal?" If we're
He
out
didn't
the
get a
money,
deal. He didn't get one.
sir.
He didn't get a deal. He
Sir,
got a deal canceled. His deal got canceled.
yeah.
All
You
right.
can serve 2 years, is what the law says. You can serve up to 2 years, and that's and a deal, and a plea agreement. Look it up. There's no right under law for that. There is no right under law, and you're looking at up to 2 years. That's what the law states, and I don't have to accept it. It's a privilege that's trying to move cases. But if the people say we need our restitution back, they're going to get accommodated. It's not right. If I was injured and they got a deal, did they? Well, that's nice. Where's my $600? There's no way you can find that money. There's no way somebody can help you with that.
No, you don't give that chance. You don't give that kind of chance. You're going to let me out of jail. I was going to get the restitution money, and then we just weren't going to do that because there was restitution
this wasn't
money,
a probation.
and now I'm not going to do it.
This wasn't a probation.
So 6 more months. Then 6 more months.
This wasn't a probation.
over 600.
Okay. No, we just said for trial. That's all. I didn't know. Thank you.
You got to know how to decide something, Judge. You got to decide something. You can't,
Sir,
I'm
I'm sorry. I'm sorry. You don't make the rules in this courtroom.
No, I make decisions.
The law
I make
does.
decisions.
The law does. The law says you have a right to a trial, and we will accommodate that. We'll set it for trial. Thank you. Well, that's 20 minutes of our life we'll never have back.
Yep. Okay. Go! Will you hand me my screen box?
Now go.
Do I have Liridon Somani here?
Yes, Your Honor.
Do I have the officer here, Officer Pugh?
Yes, Your Honor.
Oh, there you are. I haven't seen you in a long time, Sergeant. Your name?
Sergeant Nate Pugh with Trenton Police Department.
And Mr. Somani, your name again?
Laradon Salmani.
All right, so he's charged with 5 over. Did you look at his record?
I did. I didn't see any points or anything recently.
Well, he's got all kinds of stuff on here.
Oh,
Let
okay.
me
I didn't see anything when I ran it the other night.
There was a data crash, failure to yield 18. Hazardous action. They cited him with a hazardous action. Failure to yield in 19. Operating while impaired 20. Failure to stop assured clear distance 22. He was found not guilty of another drunk driving, speeding 24, speeding 24, speeding 24, speeding 25. Yeah. Do you want to admit responsibility or do you want to have a hearing, Mr. Somani?
All I really wanted to do was get the ticket reduced.
I know. Well, you can't do that when you got a record like that. Okay, there's nothing I'm going to do for you. Sorry, you got to slow down. You got to be more careful. Okay, so do you want to have a hearing now or do you want to plead responsible to 5 over?
Man, we can have a hearing since we're here.
Raise your right hands, both of you. You solemnly swear or affirm. I got to see your hand, Mr. Somani. Solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got, Sergeant?
Yes, I do.
Mr. Somani? You look like you're scratching your forehead. I'm giving you an oath, sir. Are you taking the oath?
Yeah, I'm sorry, I just couldn't hear you.
Do you solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got?
Yes, Your Honor.
Go ahead, Sergeant.
On February 21st, 2025, I was on patrol with the Trenton Police Department where I've been employed for 7 years. It was about 5:20 a.m. in the morning, and I was traveling eastbound on West Road near Westfield. I observed a black sedan, which was later identified as a 2013 black BMW traveling westbound toward my patrol vehicle. The vehicle appeared to be traveling in excess of the posted speed limit, which was 35 miles per hour. I activated the front moving radar on the patrol vehicle that I was operating, and the target window read 50 miles an hour. The patrol speed matched the speedometer on the patrol vehicle, and the radar unit was tested prior to my shift and after my shift. I pulled the vehicle over in the area of West Road in Westfield, and I made contact with Mr. Salmani, who provided his driver's license upon request. He was unsure of what his speed was or what the speed limit was on West Road.
Any questions of him, Mr. Somani?
Yeah, the only question was at that time there was other cars going past me, and also he cut off a U-turn. So I'm not sure if he clocked me or he clocked somebody else, but there was other cars that passed me, and which he did state as well. The officer is I just moved to the side of the area. I did not know what the speed limit was.
I do recall that. I do recall that there was a couple of cars in front of him, but I did not. I waited for those cars were cleared past my patrol car when I activated the radar unit.
So you're admitting to
Any
the
other
question,
question?
right? So you basically admitted that these cars were going faster
Hang on.
I'm just saying, Your Honor, he admitted these cars are going faster than me.
Okay, well, listen,
I'm just saying that's not fair. Like, if there's cars going faster than me, how I'm the only one who gets pulled over?
That's not what I said, sir.
That's what you basically just stated.
No, it's not.
Mr. Somani, wait a second.
You basically just stated that. Mr.
Somani, wait a second. I didn't hear him say that.
He just said
Settle
correct the
down.
cars past you.
Sir, do you have any other questions of him, or do you wish to offer testimony?
All I'm just saying is I didn't think it's fair when he did a U-turn. He pulled me over and there was cars going past me. So I'm not sure why he was pulling me over at that moment. And I told him, I was like, I'm not familiar with the speed limit around this side of the road because I just moved to this side. That's all. And he told me he ran my record. Then he came back. He said, if you come to court, we can reduce the ticket. That's what all that was stated. But like I said, the point I'm making is I'm not sure if he accidentally clocked somebody else over, but there was cars that went zooming past me as well, another two cars, and he hit a U-turn and pulled me over. So I was just kind of confused.
I can clarify what I said.
Go ahead.
There was two vehicles that were driving in front of him. They passed me, so they were out of my radar antenna. I activated the radar, and then that is when I picked up Mr. Salmani's BMW at 50 miles an hour.
Do you know how fast you were going, sir?
I was not paying attention to how fast I was going, but I know there was cars going, like he said, I don't know when he activated, like he said, but cars literally passed me at that moment when he pulled me over. So I was confused why I was getting pulled over. I didn't think initially I was speeding because if I was speeding, I'm like, why didn't the other cars get pulled over if they passed me at the same moment? So I was just kind of confused in there.
Well, you shouldn't be confused. I'm not confused. I mean, you're driving too fast. He clocked you. He's got you at that. I'm sorry. I find you responsible as charged. Go ahead and smile. I mean, you got a bad record and you got to slow down. And 135 is your total. Can you pay that today?
No, I can pay it in 2 weeks, but I just think this is just not fair. Like he said, there was other cars passing me.
Listen. You can appeal.
Yeah, I'm going to appeal it.
Yeah, you go ahead. It's 7 days, so you got to pay it within 7 days, right? At least isn't that still the rule? They didn't change that on me, did they?
I believe that's true. Yeah.
So you got to pay. If you want to post your bond to appeal, you got 1 week. Okay, you got until April 7th. So 135, and I wish you well. Good luck. Yep. Thank you. 25B1477719. My lord, how old are you? Huh?
What?
What's your name?
Madison.
How old are you?
How old am I? 16.
She said she was gonna have to stand on her tippy toes to reach the microphone.
Was there an accident here?
Yeah.
There was? Was there an accident?
Yeah.
Boy.
At T-bone.
All right, so you're gonna plead the 5 over? Is that what you want to do? You talk to me. She can't talk from back there. Do you have any questions?
No.
Is this what you want to do?
I don't know.
Well, you could either go to the hearing on the original charge, it looks like, which is running an amber light, disobey an amber light and causing an accident, which is 3 points. Or if you take this speeding 5 over, dismiss the 3-point violation. It's up to you. So I could set it for a hearing. You can come back. Police officer will be here, testimony. But if you lose, it's 3 points. If you take this, it's only 1. You can't talk from back there, ma'am. If you want to come up here, you can come up here.
Do you mind?
No, not at all.
Okay, she's just.
The only thing is, they're not going to offer when there's serious damage to the other car impeding traffic or there's somebody injured. That's the issue here.
Nobody was injured, but
It
she
says
said he was.
both vehicles were towed.
They were, yes.
So she can either roll the dice and say, hey, I'm not responsible and I want to fight it. If she does that and she loses, it's 3 points, or she can take advantage of this. It's 1 point.
No, she is responsible and accepts that. I was under the impression he gave us 1 to 5.
That is right. 5 over.
Giving us no point.
It's 1 point. If somebody told you it's 0 points, it's 1 point.
Oh, she's a brand new driver.
I know, but she caused an accident.
Right, because, yeah, I mean.
I treat everybody in here the same. That gentleman back there that just was in here, he had no record, and same thing, he got a point. I hate to do it, but if somebody comes running through a red light and crashes my car and I wouldn't want the driver getting impeding. That's the way I look at it. People can agree or disagree. I've been doing this, and so has Judge Hessen, for a long time. We've had this policy in effect.
He told me it was 1 to 5 miles per hour.
That's 5 over. That's right. It's 1 to 5 miles.
6 to 10 was 1 point, was what he told me. Okay, if that's the best we can do for a brand new driver, then we'll take it.
All right. Don't get surly on me, okay?
No, I feel bad for her. I mean,
well, so do I, but she caused.
Yeah, and we've all been there.
I know. I'm not changing what I've done here this morning over a bowl of Cheerios, if you know what I'm saying. I can't do it. Okay? I don't relish giving people points, but when somebody's hurt or somebody's car's totaled, there's nothing I can do short of this. You got a 3-pointer to a 1-pointer.
Thank you.
Okay? Sorry. To that charge, young lady, do you want to proceed by pleading to 5 over? 1 to 5 over? You didn't tell them that this was 0 points, did you? 1 to 5 over?
1 to 5.
Yeah, she was saying that you told her.
You said 1 to 5.
Hang on. 1 to 5 is 1 point. You keep saying 1 to 5. It's 5 over. 1 to 5 over is 1 point.
6 to 10 was 1 point.
Who told you that? That's wrong.
I didn't say 6. I thought 1 to 5 over might have been 0 points. I wasn't sure.
And you did tell us.
Well, you don't have to do this. I haven't taken a plea yet. I didn't call you up here to.
Under the impression that.
I didn't call you up here to argue with me. I'm telling you what the point system is. I'm not the Secretary of State. That's what they said as the points. She totaled another car. I don't know what else to tell you. I'm not trying to be a tough guy here, but whatever he told you in the back, he was wrong. We all make mistakes. He was wrong. She doesn't have to take this deal. No harm, no foul. If she wants to come back and have a hearing, I get it, but this is the offer. She doesn't have to take it. Do you want to talk to her further?
No, we will take it.
All right. So 1 to 5, officer.
Yes, sir.
Is 0 points on the freeway.
On the freeway, okay.
It's limited access. But you can't, this is not. This is they changed this. It used to be, they came out with different, they changed the point system on 5 over, or they changed it. I just know what it is always, but they changed it 2-3 years ago. So to that charge, do you want to plead to 5 over, Ms. Peel?
Yes.
All right. So to 5 over, I need you to either tell me responsible or not responsible.
Responsible.
All right, I'll accept the plea. The amber light is dismissed. 195. Can you pay that today, or do you need time? I'll be glad to give you time if you need it. All right, good luck. Take care. Diamond Mercedes Gee, 22B141007. I need Ms. Wilds in here.
Sure, what has to have Diamond G?
Ms. G, your name, is it G or G?
It's G.
Your name?
Diamond G.
All right, so she was getting an updated letter.
So Judge, she has a doctor's appointment today at 11, and that's when she can get an update.
I thought I moved this from the 13th to today, so
She
she.
move it to that day, but she indicated that she can't get another letter from her doctor until this appointment.
All right. Ms. Wilds, and you said she's going in the next day? Today?
Today at about. Yeah.
So, all right. When's Mr. Haynes? When are you here again? I don't know. You just give me a date, Lisa.
Back on April 14th, 8:30.
All right, that's what I'll do, ma'am. You go down the hall, get your notice. April 14th at 8:30. I'm sorry, Ms. Wilds. Turns out she didn't get the letter. She's going to the doctor today. So what?
I got the letter.
You have the letter?
I have the letter.
From the doctor?
I'm sorry, no, you had asked for a letter from the treatment specialist, that's what I have.
You want to tell me how many times she went?
Your Honor, it's a complete letter that indicates the individual sessions that she attended, as well as all of the missed sessions that she attended. She was supposed to be doing group sessions. She's only attended one of those. That was back in September. I did speak with her therapist, Ms. Sims, who indicated that they do have a plan now moving forward. But this does have all of the misses on it if you'd like to see it, Your Honor.
How many misses?
13, and I will say
And how many times she go?
how many times she did, again, one group.
Yeah, I know, but individual. She missed 13 individual sessions, right? Is that what you're telling me?
She has attended 20 individual sessions. She's missed 13. I will say that again, within that, one of those 13 was when the staff was unavailable. The other times are when Ms. G did not appear or Ms. G canceled. And this would be since her intake in July.
All right, and she's only gone to one group.
One group.
So I'm gonna count it as 12 missed. You're making this difficult for me, you know that, Ms. Gee? I'm sorry, is it Gee or G?
It's G.
Why are you missing so many sessions?
A lot of times it was either my daughter was getting sick and then I would get sick, or it was stuff like that. And I have that. I didn't print none of it out, but I have everything in my chart with the same dates that apply to it that I miss.
Say that again?
Okay, so I'm saying I have every date that I missed was from something going on with my daughter or myself.
All right, so you pled guilty to failure to clear warrants, failure to do the victim's impact panel, failure to pay fines and costs. I don't know what I'm gonna do with you.
Judge, the other component in this, there was some kind of a program, I think, through Wayne County that was going to give financial assistance, which would allow her to go in and clear the warrants and post the bond.
You just are not, she's not following my directives though. How long did I tell you to clear, that you had to clear your warrants?
I didn't have the funds to pay for it.
I didn't say if you have the funds.
But that's.
Judges are not ogres, ma'am. We want people to show up and at least talk to us. Wait a minute, stop, listen. I told you in July to clear your warrants by September 1st. You didn't clear your warrants. This is now 7 months later. And you're standing here and you're not going to treatment. And it's time to grow up. Is this your first child?
No, it's not. It's my second child.
Well, it's time to grow up. I didn't say anything about go in and talk to the judges about your warrants when you had the money. There are not. How many warrants does she
have? 8, Your Honor.
8. So now I got to put a pregnant lady in jail, or just let it go again? Is that what this is? Is that the defense? Judge can't put me in jail because I'm pregnant?
I never said that.
I didn't say you said that, but that's what I'm thinking.
Okay.
You're due in a month. You haven't done anything.
What haven't I done? Everything.
You didn't pay any of the money.
I didn't do it when you guys had the date because I didn't have the funds.
Don't interrupt. You could have come and talked to me. Did I not tell you that multiple times? Did I tell you that or not? It's not that hard. You pick up the phone. Can I talk to the judge on Zoom? Or you come in here on or before any due date. I'd have been glad to give you an extension. And here we are 9 months into your, more than 9 months. Well, I guess about 9 months. We're 9 months into a 14-month probation term. We don't have exactly a good report from the therapist. She didn't do the victim's impact panel either, right?
She did it after the fact, Your Honor. So since the violation, she has completed the VIP.
What are you suggesting here, Mr. Haynes? I mean, really,
Judge, it looks like it's gonna take extra time to get this done, especially the financial component. We would ask the court to consider extending probation.
Probation's up when now, Lisa? Beth,
I have September 17th.
of 25, right?
Yes, Judge.
So I can take it out to January 17 of 26. How are you supporting yourself, ma'am, right now? How are you supporting?
I get cash assistance.
Is there any other, a bridge card? What do you get? Tell me what you're getting. How much do you get per month?
Like 3 something.
I'm sorry?
Like 3 something,
Hey, guys,
split up into 2 different payments.
wait a minute. You keep your voice up, please.
3 something split up into 2 different payments.
Per month?
Yeah,
That's all you get?
yeah.
Well-
I can't work right now.
Is the father in the life of you and the child? Or
Yes, but this is not his case. This is my responsibility.
All right. When do you think you'll be going back to work? August? September?
They said that I had to wait 12 weeks after I give birth. So,
I'll tell you what, I'm gonna extend probation for 5 months until February 17th of 26. You're gonna pay additional probation fees of $100. I won't assess any costs. Defendant to pay $150 per month beginning June the 1st. I'm sorry, beginning August the 15th. Well, wait a minute, May? You said you're due beginning September the 15th, but all money due by January the 31st of 26. Defendant may set hearing date and request this to be done, to be paid by community service. So in other words, I might let you do community service instead of paying fines and costs. Do you understand that? So if you said to me, Judge, I just don't have the money, I don't have a problem. You come in here and talk to me and I'll be glad to convert this to community service if you'd like.
okay.
Okay?
Yeah, she still has her initial community service left to do with her doctor's note. She is indicating she won't be able to complete that or even begin that until, again, those 12 weeks are up as far as starting her initial community service.
40 hours of community service due to be completed by, I'm just going to say September 15th.
We'll call the case of the state of Michigan versus David Hatton, 19-00069.
Tiffany Woods for the people.
Paul Barnett on behalf of the township.
Assistant Public Defender Davi Lebo for Mr. Haddon. Mr. Haddon, could you state your name, sir?
My name is David Head.
Thank you, Mr. Hatton. All right, we're here today for a sentence. We're supposed to be here for a sentence and a payment plan review. Mr. Hatton failed to make and keep his appointment with Matt Statman, according to the report that I had.
Yes, Your Honor, I did talk about this with Mr. Haddon. Mr. Haddon has indicated to me that he's had some difficulty getting a hold of Mr. Statman. I did ensure that Mr. Haddon has the correct phone number for Mr. Statman, so I'm hopeful that if he's given an additional opportunity, he'll be able to complete that assessment.
Judge, this is the second time now that this defendant failed to do his assessment. We already
Please don't talk over her, Mr. Haddon.
Back in February 24th, he didn't complete his assessment, Judge. And you ordered him to do that assessment. He still hasn't completed it, Judge. So I don't know what it's going to take for this defendant to complete this assessment. I mean, at this point, are we looking at putting him in custody to get that assessment done? Or, I mean, he's really not leaving us much of a choice, Judge.
Thank you. You make a good point. Mr. Lebo.
Your Honor, I think that Mr. Haddon is understanding the importance of getting this assessment done, particularly with the understanding that if he's given an additional opportunity today, it's going to be his last opportunity before potentially being remanded. So I think that if he is given that additional opportunity, he will understand and appreciate that and get that accomplished before the next court date. Isn't that correct, Mr. Haddon?
Yes, sir. Every time I called the man, he ended up not answering the call. Then when I called the probation officer, they gave me a number. I called. He don't answer the phone. He called the probation officer. The probation officer said that I did do what I was supposed to do. He put me on a list. I don't know what the list is called, but he put list. After he put me on the list, I was 5 minutes late from answering the call. Then that's when he said I gotta wait till April. Then I called. My lawyer called me and said, did I do the assessment? He said I was 5 minutes late. Then I gotta reschedule it. It's hard to get in contact with that dude to do that thing that y'all asking me to do.
Well,
But my probation officer got proof that I did call repeatedly times, left voicemails, and he only got back with me one time. Said cause he was packed. And I don't know what to do. Like, can I pay the money? And I asked my lawyer, like, if I pay the money, since I already did 75 days under this case, if I pay the rest of the money today, is it possible that this case can be gone away?
Are you done, sir?
Do anybody hear me? Yes, ma'am.
I said, are you done?
I said, yes, ma'am.
All right. So the answer to your question is no, the case can't be gone away. The reality is, sir, you were here back on in February, like the prosecutor said, and I made it very clear then that you had to have this report done or you would go to jail.
I'm trying to do it. He won't answer the call. Like, I don't know why it's only one person doing it. Like, he ain't answered the call. My probation officer called up there. He looked at the voicemail. I'm gonna say the voicemail asked me what's my number. I gave him my number. My number's still the same. Then he put me on the list because he wouldn't answer the phone. Like, I don't know. I'm trying to do it.
Apparently you were not done. Sir, I
You said
made
what?
it clear that you needed to get this done and it was not done, like I told you to. So at this point in time, it looks like I have no option but to put you in custody to make this happen. Because you're the only person recently that's coming back and telling me that Mr. Statman is not answering his phone after the second time. So
He's not answering the phone. I can call it right now while we on the phone. And he not gonna answer the phone. He not gonna call me back or none of that. I call the probation officer. They'll call, then Statman to call him. But I've been trying to call him. Been trying to set it up and everything.
And Your Honor, I do believe that Mr. Haddon does have a fairly significant amount of credit on this case.
and that is relevant in what way when I cannot get him sentenced because he hasn't completed his assessment?
Your Honor, I certainly understand the importance of Mr. Haddon completing the assessment, but if the maximum sentence would already largely be served by the time of sentencing, I would ask the court to consider that and not remand Mr. Haddon.
I considered that when I did this the first time and told him to get it done.
I'm trying, Ms. Washington. I called the man several times.
I don't need you to repeat that to me again, please. I'm gonna pass this case. The only way I'm not going, and it appears he had an appointment and he was late for it. So that's the other problem. I'm gonna pass this case, schedule another appointment right now, and I'll recall it and decide whether or not I'm just gonna do a remand. Mr. Hatton.
You said, can you
Call
repeat that one?
Mr. Hatman right now and schedule the appointment.
Call Mr. Stapman. Okay, I'm finna call the probation officer and let them know I'm finna call Mr. Stapman.
I just told you to call Mr. Statman.
Every time I call Mr. Stapman, he
Okay,
do not answer the phone.
okay, all right. I'm passing this. Either you have an appointment or you don't when it comes back. If you don't have an appointment, then I'm going to issue a bench warrant. Yep.
Thank you.
Is y'all through?
Apologies, Your Honor. I did speak to Mr. Haddon in a breakout room. I believe he is currently attempting to make that appointment.
All right. I'll keep passing it. You should try to talk to your client, see if he has his appointment, because I'm going to call it. And like I said, if he doesn't have an appointment, I will be bench warranting him. You may
I
want to.
did it.
You did it?
Yes, ma'am. It's April
Sir,
Thursday, the 17th at 8
Mr. Haddon, can you
o'clock.
stop for a second, please?
Court will recall the cases of the state of Michigan versus David Hatton, 19S00069 and 18W006721A.
What's for the people?
Paul Barnett on behalf of the township.
Assistant Public Defender Donovan Leba for Mr. Haddon. Mr. Haddon, could you state your name, sir?
My name is David Haddon.
Thank you. All right, Mr. Haddon, you're telling me that you've made your appointment, correct?
Yes, ma'am.
Interesting.
Yes, and he said the same thing. He said, I have been trying to call, and he asked me, did I leave a voicemail? I said, it's not showing up on his end that I left a voicemail. I just left a voicemail when you told me to do. He still didn't answer.
Yeah, but he apparently did something. You have I'm not even going to argue with you, Mr. Haddon.
Because I kept calling. Like I called him 3 times just
what
now.
you need to do beforehand, before today. All right.
I never know. I've never been on probation like this.
We're going to schedule this for sentencing again. The only reason I'm giving Mr. Hatton another opportunity is because he does have 75 days credit at this time. So I'm taking that into consideration. Mr. Hatton, you need to keep that appointment that you have on April 12th, you said?
No, April 17th, at 8 o'clock.
All right. Do not be late. All right.
Yes, ma'am. Okay, now, once I get through doing this, when is my next court date?
I'm getting ready to give you that if you would let me, sir. Okay?
My bad. I'm sorry.
May 5th, 2025 at.
You said May 5th?
Yes, sir. At 10 a.m. Your bond is continued. Sir, I'm telling you right now, if you don't keep the appointment, I'm going to issue you a bench.
I got the appointment now.
See you back here on both cases on May 5th, 2025 at 10 a.m. One last time, the person whose phone number ends in 6596. 6596, I'm sorry, 6596. 6596 are the last 4 digits of the phone number. Please hit *6 to unmute.
Oh, I'm sorry. God dang!
What's going on? I'm glad you didn't curse because that was really loud. What is your name?
Oh yes, Carlos Edwards. I had court on the 19th, but I had to go to court on the 19th in Detroit for sentencing, not sentencing.
Mr. Edwards, you're not on the docket today, sir.
Please contact the clerk's office in order to schedule an arraignment.
You need to contact your clerk's office, sir.
I gotta contact who?
The 14th clerk's office. So you can schedule an arraignment on the bench warrant that was issued from the 19th.
Right, I thought it was today at 9 o'clock.
You just told me you knew it was on the 19th.
Yeah, on the 19th. Yeah. But then I did a what do you call that? I called them and they told me to have my Zoom meeting set up tonight for 9 o'clock today, and I did it and they kicked me off, so I got back on.
Your Honor, he has a show cause hearing scheduled for tomorrow, April 1st at 9 a.m. with Magistrate Brayley.
You have a show cause on April 1st at 9 a.m. before Magistrate Brayley, sir.
Okay, that's what it is. Okay, sorry, thank you.
Bye-bye. All right, the court will call the case of the state of Michigan versus Silas Sherrod, 24S00324.
Tiffany Woods for the people.
Matthew Mansour on behalf of Mr. Silas Sherrod. Silas, can you state your name for the court, please?
Silas Sherrod.
Thank you. All right. We're here for a pretrial, and I think we're still sort of dealing with the bond violation from February 24th. In addition to that, it's not on the docket today, but there is a ticket that Mr. Sherrod has for a nuisance dog, which is 24W002904, that will need to track these cases depending on what we do today.
Okay, Your Honor, thank you. In regarding that bond violation, Silas, a few weeks ago, went to community corrections knowing he had a warrant. So they took him in and then he bonded out.
Okay, that is true, but he still needs to address the bond violation. He admitted to testing positive for amphetamines, but he denied he used it. He was supposed to submit a letter from the doctor.
Silas, did you send me that letter or no? A doctor's letter?
No, only one doctor's letter.
Okay.
I'm sorry, what did he say?
He said only one doctor's letter, but it's not a letter addressing.
Right, that's the necessity.
Correct, Silas?
That's correct.
Okay.
I stopped taking them.
Right.
So, Ms. Woods, what are your thoughts on the bond violation? Because he admitted that he to testing with amphetamines, but now he's saying he stopped taking them. I'm not sure where we are, because you're saying correct to the fact that he's now saying he stopped taking it when he denied using it when he was here on February 24th.
My medicine.
Judge, I mean, all the tests that we have show that he was positive. I think the last test was March 6th that we have a report for. Do we have any more recent reports that would show that he's not testing positive?
Sorry to cut in. There is a updated progress report. He has been testing since after March 6th, and it indicates that there's no amphetamines being found in his system. It's just whatever THC residue or THC that's still showing up. And I have that progress report.
Oh, I see. March 6th, he was still testing positive for amphetamines, but then he didn't test positive on March 14th, 19th, and 26th. You see that, Ms. Woods?
Yes. Yes, Judge. I mean, and I know that he was supposed to, even though he still has, he's showing now the negative. I mean, that he never ever got the court the, letter from his doctor. How do we know that all those positive amphetamines were from medication if he's
without a letter, I'm not accepting that it's from medication. So presuming it's not from medication, what do you want to do about it?
Are you asking me, Judge?
Yes, Ms. Woods, yes.
I mean, he's in violation of his bond. I don't know what the court would want to do about that. I would leave it in.
He posted a higher bond. He posted a $25,000 cash assurity bond now.
Right. I mean, I guess I would leave it in the court's discretion as to how you would want to handle it, Judge. I don't know.
All right, thank you.
Yeah.
Mr. Sherrod?
Yes, ma'am.
Sir, if you test positive again, I'm just going to revoke the bond. Do you understand?
Yes, ma'am.
All right. So your consequences for testing positive is that you had to post a higher bond. Apparently you went into custody and you were aware what the bond was, so you posted that. As to the pretrial today, what would you like to do, Mr. Mansour?
Yeah, I've been trying to negotiate a little bit with the people here. There's no offer on the table at this point. So we're just going to have to set this matter for final settlement conference, Your Honor, please. Unless there was an offer in the past. I mean, this case has been kind of dragging out for some time. I see since almost October he's been in pretrial status. So as of now, I am not aware of any offer on the table.
That's correct. I wanted to have him screened for some sort of sobriety or recovery court. He's not interested in doing that. And based on the fact that he has 2 prior OWIs, Judge, I'm not going to give him a disorderly drunken conduct with a referral to probation, which is what defense counsel is asking for. I'm not giving a disorderly conduct on this, Judge.
Well, let's slow down a little bit. So first of all, with respect to the recovery court, this is an operating while intoxicated. It's charged as a first offense. He may have priors in the past, but he wouldn't be eligible for recovery court because of the actual charge that he has right now. So that wouldn't be an option.
Right, but he's wanting a disorderly conduct. We
Okay.
offered.
Secondly, as to that, you don't have to give him what he wants, but there is an intermediate offer in between, and I don't know if you've offered that or not.
Well, from what defense counsel's coming back, I don't think he would take anything other than the disorderly conduct, Judge. So, I mean, defense counsel's not asking for an OWBI.
All right.
So if he is, then he can email me that, but Mr. Mansour has never come back with that counter offer.
I think he made you an offer and then you counter offer. That, in my experience, that's how that works.
I mean, if Mr. Mansour wants to email me to let me know that the defendant wants that, Judge, he can email me, but he has not emailed me any requests like that, Judge.
All right, thank you. Final settlement conference in this case is April 25th. I'm sorry. Final settlement conference is June 27th at 9:30. Can I see counsel in the breakout room?
Yes, please. Thank you.
I will pass.
What did you say, Mr. Sherrod?
I'll wait till you come back. I'm sorry. I was just wondering. I thought I was about to be hung up. I just want to know if I could have a travel pass to my sister's wedding. That's all I want to know.
All right,
Yeah, that's
we're not done with your case.
one
yet.
second.
I thought you were done.
Before we recall the matter of the state of Michigan versus Silas Sherrod. All right, Mr. Messer, where are we?
Yes, Your Honor. Thank you for that opportunity. Thank you, Ms. Woods, for that offer. Mr. Sherrod would just like a little bit of opportunity to consider that offer. He's not rejecting it at this moment. He just wants to talk to some family about it, and so I can do some additional research as well, given his past history. So if we can ask for an adjournment, Your Honor. But before you select the date, could I please ask for permission to travel request?
Sure.
Thank you, Your Honor. Mr. Sherrod's sister is actually getting married this coming month in April in the great state of Tennessee. So he's driving down there, I believe, on the 9th. And he will be there till the 16th, or he plans to be there till the 16th if approved. And I asked him if he can provide me any proof that he'll be staying there. He said he's renting a car and will be staying at a hotel, which he could provide to me as soon as possible, if you would allow it, Your Honor. He's, obviously willing to test before and after he comes back, or whatever it deems necessary.
Ms. Woods?
Judge, I, again, would just, is there a proof that she's getting married? Usually we have proof of wedding announcement or something. And then I would just leave it up to the court's discretion.
I'm sure we can get some sort of proof of whatever you need, Ms. Woods.
All right, upon proof of the wedding and where he is staying, defendant may. What, Mr. Sherrod?
Oh, no. Nothing.
He said from the 9th until the 16th?
Yes, I'll be back on the 16th.
That's a long time to be gone for a wedding.
Well, I'm saying, man, her actual day is on a Saturday. I'm taking my mom. her husband, and we're all gonna go down there. My mom wants to be there the day after she gets married. She's gonna watch my niece and nephew, and then by that time I'm gonna leave and come back. She wants to be there to help her get ready, and then after her wedding, then she's gonna watch the babies, her niece and nephew. Then I'm coming back. I mean, not niece and nephews, my niece and nephews, her grandbabies, and then I'm coming right back. If I get back before then, I know, like you said before, go straight the day I get back and report.
Well, here's the thing. You must test before you leave, the day before, and immediately upon return. And if there's a sober link available, he's to have a sober link while he's going. He can return it when he gets back.
Understood, Your Honor. Thank you.
I'll put all of these over to April 21st. The case today, as well as the nuisance dog ticket to April 21st. So you're going to be required to blow in the sober link several times a day to make sure you're not drinking while you're gone, okay? Did you hear me, Mr. Sherrod?
Oh, that's for me to blow in something to make sure I'm not drinking?
Correct.
Every day, keep just blowing it every time it says it?
They will give you a schedule that you need to follow when you go pick it up, sir.
Oh, not a problem.
Okay. Thank you, sir. You're all set. We'll see you back here on April 21st at 9:00 a.m.
Silas, I'll give you a call, okay?
Yeah.
Ypsilanti Township versus Deshauna Parham, case number 24T00286.
Paul Barnett on behalf of the township.
Assistant Public Defender Daffy Lee on behalf of Ms. Parham. Ms. Parham, can you state your name, ma'am?
Deshauna.
Your full name, ma'am.
Deshauna Parham.
Thank you. All right, we're here for a pre-trial. Apparently she has final settlement conference. Did that get canceled? Final
No, Your
settlement
Honor.
on April 25th and a jury selection on May 2nd?
Yes, Your Honor. The court had set this date, I believe, for Ms. Barnett to indicate whether or not he was expecting to be able to proceed with trial.
Oh, okay, thank you.
Oh, shoot. I'm sorry, Your Honor. I'm not in a position to answer that today. I'm sorry, it's slipped through the cracks. I need to reach out to the victim.
Mr. Lebo?
Your Honor, I would ask the court to consider a bond modification at this time. Ms. Parham does indicate that she would be willing to stay in Michigan under the pendency of the case, and we would have no objection to a tether to ensure her appearance.
Where is she going to stay at? Does she have an address?
Ms. Parham,
Huh?
do you have an address where you could stay if you were released?
Yes.
Thank you. She has not provided that to me yet, Your Honor.
I'm not going to do that right now. Mr. Barnett, I'm going to put this over for 2 days.
That's fine.
Right, I'll put this over to Wednesday, Wednesday, April 9th at 9 a.m.
That's fine. I apologize. I had this down as a pretrial and I didn't have that additional information in there.
Oh, I'm sorry. It's be the 2nd, April 2nd.
Thank you.
Bond is continued as is. You're all set, Ms. Parham?
You didn't say nothing, bro. What the hell?
I'm sorry, what did you say?
I don't even know what's going on, bro. What? Like, I don't know what is it, bro? Like, what?
I'm not your bro.
I don't understand. Why is it being pushed back? For what?
Well, first of all, your court date is April 25th. I could just continue it to then. But I'm trying to find out whether or not.
No point in me even coming down. Wasting my time, bro. What the hell?
Please mute her.
We are on the record in the matter of the City of Wyandotte versus City of Riverview versus Annalise Martinez, 241607.
Good morning, Ricky Keys, Toronto, P33828. Today, Your Honor, I appear on behalf with my client for purposes of sentencing. Please state your name, ma'am. Also, there is a violation of probation allegation.
Yes. Okay. And your name, please? Annalise Martinez. Okay. So there are two things up today. Probation violation as a result of this conviction, I'm presuming.
Yes.
Yes. And then also sentencing on your plea to count 2 of disorderly, your assault battery had been dismissed. And so let's, I don't know which one we want to handle first, but let's handle the sentencing first on the 241607.
All right, Your Honor, my client, and we have allegation, my client is 19 years old, she's single, she lives with her mother. Your Honor, at this time, she's not working, but she's looking, and she's not under doctor's care, takes no prescribed medications. If she were tested today, she tells me there'd be no drugs or alcohol in her system not prescribed for her, Your Honor, and we think the recommendations are good in terms of the sentencing aspect. I think she's a good candidate for probation. I think she'll successfully complete that. Your Honor, we have concerns about the other aspect, but we'll wait for your decision on the sentencing, I guess, unless you want to combine them.
Okay, well, let me ask a couple questions. First, is the PSI accurate?
Yes.
Okay. Second, is Marianne Kingsley or Kayla Langford present?
And as to restitution, Your Honor, I did get in the file that says the alleged victims or the victims in this case. We're asking for no restitution, Your Honor.
Right. So, why aren't you working?
I'm currently looking for a job.
No. Okay. I need you to speak up a little bit louder, please, so we can get you on the recording.
Speak up.
So you're looking for a job. How long have you been looking for a job?
For 2 months now.
2 months.
Yeah.
And there's one job that you've been offered a position at.
I got applications and interviews, but I only got brought back to one interview and they didn't accept me to come back for the job.
Okay. How many applications have you submitted?
At least 60 of them, because I have to submit them to you guys.
Right.
Yeah.
You still haven't had a job?
No.
So what do you do all day?
I do DoorDash and Instacart sometimes.
Okay, so you are working.
Well, it's not for a company. Yes, she does DoorDash, but you know, she tries to do it every day. Is that correct, ma'am?
Yes.
Okay, so you have a real problem with your inability to control your anger. And who is with you today?
Boyfriend.
What's his name?
Day one.
Good, at least it's not Cameron Hampton. You were with Cameron Hampton the last time you got in trouble too. And you're currently on probation in Allen Park as well, correct?
Yes, and I'm currently supposed to go to court on the 4th, but they moved my court date till May 5th to get off probation.
Okay, well, when you were sentenced on your other matter that you're currently on probation for, you're working at the La Quinta Inn. Why are you no longer working there?
They don't have any more like hours to give out, they said, so I just stopped working there. Because I was getting 10 hours a week and it wasn't working.
Isn't that better than 0?
Yeah, it is.
Oh, and the other matter, I remember. The other one was when you took the bike from a kid that was riding in the neighborhood. And now, in this matter, you got in a fight with people at Zorbas, right? Okay, so.
Well, Your Honor, yes, I recall it vividly. I watched a long video up there.
So.
It wasn't really a fight, a big melee, I guess you would call it.
That you were in the middle of.
Right.
So what gives?
I'm currently on probation still for the other.
Yeah.
Okay.
When I say what gives, I'm actually asking what gives in relation to your behavior and why you continue to behave the way you are.
It was just the people I was around and wrong influences. Being around them and hanging around the wrong people.
Yet you were still hanging around with them. You would think after the first time that you were in trouble and that you were on probation in Allen Park, that you would get it together, and you didn't. And in fact, I think, aren't you on probation for larceny out of Allen Park?
Retail fraud.
Okay, retail fraud. And then you stole somebody's bike. While you're on probation out there, you had a case pending there, and you stole someone's bike. Now you're on probation in both jurisdictions, and now you're acting a fool in a restaurant. And here you are again. And your attorney is trying to convince me that you are a good candidate for probation, which I don't know that you are. In 1 year's time, you now have 3 convictions. 3 convictions. I gave you a chance the first time, and here we are again. Here's what that chance is. I gave you a chance on probation, and here you are. Why, ma'am, should I put you on probation yet again?
Because I will make the right choices and pay probation, and I'm currently doing community service to give back to the community for the other stuff I'm doing for probation.
What are the right choices that you've made?
I'm currently looking for another job. I did some of my community service. I did CASA classes. I paid a $50 class fee that you guys gave me to do, and I completed that also for my other probation.
Your Honor, I would, as to the violation of probation, she's going to plead guilty to that. Obviously, she can't have a defense for picking up another case. So we're hoping the court is going to put those 10 days in jail recommended in a jail review status if the court deems that fit. Just give my client a chance to come back and say, yes, Your Honor, I'm looking for more gainful employment. I'm doing the right thing. I'm not hanging around the people that I was hanging around with before. So, Your Honor, she's at a young age now. She has a chance to turn her life around. I think she's confident that she can do it with herself. It's just that I think in the past she was easily led to be hanging around with these groups of people. I mean, even in the video, she was not as bad as some of the other actors in the videos, but again, that isn't a defense, but we'd hope the court would consider that in fashioning the overall sentence. She was cooperative with the police, I mean, during the booking process, the whole throughout.
All right, I'm gonna have you please raise your right hand on the jail review, or on the probation violation. Solemnly swear from the testimony that's given this matter, the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
I need you to speak up, please.
Yes, ma'am.
All right. And so, you heard the allegation is that you are on probation in the 27th District Court here, correct?
Yes.
And that your conviction on 241607 triggered a violation for your probation violation, correct?
Yes.
And as that violation, how do you plead?
Guilty.
Counsel, can you please pardon your client?
Ms. Martinez, you agree you're on probation to this court?
Yes.
And part of that probation was that you, a number of things, but one of them was that you received no new cases. Is that correct? No criminal cases?
Yes.
And in fact, you did, and that is the matter that we're here for, the sentencing. You pled guilty, correct?
Yes.
You disorderly conduct, correct?
Yes.
I'm satisfied, Your Honor.
And the court will accept your plea. All right, here's what the court's going to do. On your probation violation, the court's going to adopt the recommendation. The court's going to order 10 days jail. The court's not going to order jail on your other matter. The court will give you the benefit of probation. Once again, one violation is revoked and you're spending the remainder of that in jail. Do you understand that, ma'am?
Yes.
Is that yes?
Yes.
As to the 241607, the court does find there's reasonable grounds for Department MCL 769.5. The court also finds the following sentence to be in the best interest of justice, reasonable proportion to the seriousness of the matter and circumstances surrounding Ms. Martinez and the legislative guidelines. The court's going to order 18 months probation. You're not to return to Zorba's Coney Island. You are to participate in a 12-week anger management class. The court's going to also order, well, I tell you, I'm a little bit nervous. I'm going to order to community service given the behavior. But you're going to perform community service without any issue on the other matter? The court's going to order 100 hours of community service to rehabilitate both for that condition so that you can further develop work and life skills and get back to the community. The court's also ordering you to seek and maintain full-time employment. So you're gonna go out this door today for your 10 days, and then that will be done. And then you'll come out, you'll be discharged from jail, and then you can start fresh with all your conditions.
Your Honor, would the court consider anything besides straight 10 days in jail?
No, this is her third case in 1 year. She's violated probation. No, 10 days jail.
Thank you, Your Honor. I have seen the box over there. Turn right.
There. Thing about this court, it's an adventure. Like a box of chocolates. You don't know what you're gonna get.
Are you kidding me? Oh my God. You have got to be kidding me. What?
What is going on today? This is a joke. Today is an absolute. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're gonna start bringing people in first. People gonna learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
Come and go, so no face left. Trust me, at the end of the day, I'm sitting up here, I'm the one that needs a drink.